Good evening, everybody who's here, and good evening for the several hundred of you who are not here but watching. This is the 12th Hugh Laddie lecture, and I'm glad we're so glad that we are not totally online. Not only are we not totally online, but we've got an actual speaker here who has kindly come from NYU for this, and of course to go with his nephew to watch Manchester United. Barton is one of the lecturers or professors who think deeply about what trademark is and is for, and how it's working. And I can hardly wait for him to tell us why it's all going wrong. Barton.
Thank you. Well, thanks very much, Sir Robin. It's delightful to be here. I'm a little concerned. We went for tea just before this, by which I mean we went to have a few pints in the faculty lounge when I was told hundreds would be tuning in, so I hope I will live up to expectations. I'd like to begin by saying how honored I am to present the annual Sir Hugh Laddie Lecture. I never had a chance to know Sir Hugh personally, but of course I know him by his extraordinary legacy and the profound affection I've heard so many express for him. 20 years ago in 2001, Sir Hugh gave his Burrell Lecture the decidedly unequivocal title, National IP Rights, a Moribund Anachronism in a Federal Europe. In the lecture, he ardently wished the community trademark system every success, and did so with great cosmopolitan charity. It may be that I'm here to report to you that, at least in some ways, the system has been just as successful as Sir Hugh had hoped, perhaps too successful, so much so that it has now become a victim of its own success. The title of my talk is decidedly less punchy and sadly more academic, far more academic than Sir Hugh's, and it's almost a paragraph in length. I could barely fit it on this slide. Is Europe running out of trademarks? An empirical study of trademark depletion and crowding at the European Union Intellectual Property Office. Preliminary results. I added the preliminary results on just a moment ago for reasons I'll explain later on. These results are based on work I've been doing for many years now with my co-author, Professor Jeanne C at NYU. Before I present to you our basic claims and the data that we hope support them, let me step back a moment to propose some context for the topic I will address. Through the course of the past 150 years of modern trademark law, the many national and regional trademark systems around the world have largely harmonized their policies, their laws, and even their procedures. Differences, of course, remain, some of them significant, but on the whole, they pursue the same basic policy objectives through the application of the same basic rules and standards. Imagine a sophisticated trademark lawyer advising a global business on the adoption of a global brand name. I put it to you that whether she be based in New York, London, or Beijing, she will rarely need to be concerned with specific differences of law. Instead, she would think in terms of a global trademark system consisting of various national, or in the case of the European Union, regional subsystems. What would distinguish these subsystems for her are not questions of law, but of fact. And the most important fact question by far would be whether the brand name her client wishes to adopt globally is already claimed in any of these subsystems. And I suggest that her most important practical question would be how to prepare the client for the fact that it almost certainly is already inevitably claimed somewhere by someone. Perhaps you have had this experience. I see some nodding in the room. Perhaps your day consists entirely of this experience if you are in the marketing business, especially if you're seeking to clear an English language word, especially if you're seeking to clear it in Europe or in the UK or the US, for that matter. If you have had something like this experience, I'm here tonight to tell you that you are not alone. My basic claim this evening takes the form of a prediction of the future. It is this: the most significant challenge the global trademark system will face this century will likely be the problem of trademark depletion. The problem, in short, that nearly every potentially good trademark has already been claimed. In the American vernacular, the frontier is closed. Or if you will permit a more abstruse reference, Malthus and Marx and Borges have found each other at last. Global capitalism has reached such a wondrous stage of development that it is beginning to run out of words. To support this admittedly rather grand or grandiose assertion, I will focus here on the European Union, a European Union trademark system. In past work, Jeanne and I have studied trademark depletion and trademark crowding, terms I'll define in a moment, in the US trademark system. In our current project, we are focusing on Europe and the 5 major European languages: English, French, German, Italian, and Spanish. We find that depletion and crowding are as bad as, if not worse, in Europe than they are in the United States. And they are worse for reasons that bode very poorly indeed for the continuing viability of the global trademark system. To develop this claim, I'll start with a bit of theoretical background and define some terms. In the process, I'll present very quickly some updated results from our US study. We'll then turn to the main event, the European data. Finally, I'll briefly consider potential doctrinal and policy options such as they are. The conventional wisdom in trademark law and policy has long been that the supply of potential word marks is inexhaustible. Here is a representative quotation from William Landis and Richard Posner, the former a Nobel laureate in economics and the latter a prominent American judge of whom you may have heard. They write, "The distinctive yet pronounceable combination of letters to form words that will serve as a suitable trademark are, as a practical matter, infinite, implying a high degree of substitutability and hence a slight value in exchange." And you may imagine the context in which this American court, in a classic old Coca-Cola case, observed that plaintiffs' rights are limited at most to 2 words. All the rest of infinity is open to defendant. The strong version of this conventional wisdom is that there will always exist an inexhaustible supply of unclaimed trademarks that are at least as competitively effective as those already claimed. And who can blame those who hold these views? After all, the English language alone famously consists of an enormous number of words. The OED tells us that 171,000 are currently in use. Google tells us that its Books project has recorded the use of over 1 million different English words over time. And by the way, there are other languages from which to draw trademarks. And of course, you can always coin new so-called fanciful marks, though marketers will insist that common, pre-existing words are altogether preferable. But even though this is the conventional wisdom in trademark law and policy, the popular press occasionally publishes stories questioning this wisdom. A few years ago, the New York Times Sunday magazine ran a story about product naming. In it, the author asserted, apparently thinking the proposition so obvious as not to need a source, that, quote, almost every naturally occurring word has been claimed, which is why namers so often arrive at portmanteau or drop vowels or change letters. Or here's what a company executive told Bloomberg. Every name we liked, either somebody already had it or it wasn't trademarkable or it meant something pornographic in another language. And you may have heard of Facebook's recent own goal, at least in the Hebrew-speaking world. Meta, it turns out, means dead or is dead in Hebrew. A few years ago, Jeanne and I set out to test empirically these kinds of claims, that everything is taken, in the US trademark system, and to quantify the effects they assert. We used the USPTO's 2017 Trademark Case Files dataset. At the time, it contained 7.4 million observations detailing trademark registration applications filed from 1870 through 2016. We also systematically collected, that is to say scraped, the full text of all 2.1 million PTO trademark office actions that the PTO issued from 2003 through 2016. 2003 is when they began to be posted online. The dataset is now up to about 4 million of these office actions. To compare phonetic similarity, we created a dataset of phonetic representations of all text marks in the USPTO dataset. We also used a well-established American English corpus to determine the most frequently used words in American English. We used US Census data to study frequently occurring surnames, and VeriSigns.com zone file to study depletion of .com domain names, and there are like 120 million .com domain names. What we found, among much else, is high levels of trademark depletion, which we define as the process by which an increasing proportion of competitively effective trademarks are claimed by one or more registrants. As levels of trademark depletion increase, it becomes more difficult for market entrants to find marks that are not identical or closely similar to already claimed marks. The headline of our study is that by 2016, 75% of the English words Americans use on a daily basis identically matched an already registered mark at the USPTO. And I should mention that when you take into account close similarity rather than letter-for-letter identity, the proportion jumps to nearly 90%. Here's a quick glimpse of what words remain unclaimed. Of the 1,000 most frequently used words in American English, 187 did not match a registered mark at the PTO. You may not be surprised that no one has adopted as brand names such words as dead, died, killed, difficult, problem, or violence. Though depending on your opinion of the great libertarian paradise of the United States, maybe you are surprised. If this were an all-night lecture, I could go into much greater detail with a good deal more rigor. But this may give you a quick sense, admittedly quite quick sense, of what we kept finding. All the best words are already claimed, and not just overall, but even in individual classes of goods or services. As for surnames, by 2016, 55% of the US population had been born too late to register their surname as a unique mark. And that applies to me, both my surname and actually my first name as well. And given the wide diversity of surnames in the multi-ethnic US, that's saying something. And by the way, the proportion is higher, 68%, when you take into account close similarity. What about potential neologisms, coined fanciful terms? If the law and economists are to be believed, a company can just come up with an exotic newspeak term, even perhaps an alphanumeric license plate number of a mark. Potential coinages that would actually make viable, competitively effective marks proved more difficult to study, without question. But we looked at syllable usage in American English and on the PTO principal register. Here too, we found high levels of depletion, so that by 2016, over 80% of syllables Americans use on a daily basis matched a single word trademark registered at the US PTO. And by the way, these percentages are also quite high in particular classes of goods or services, but I'll skip through that in the interest of time. Given these trends, it makes sense that Section 2D refusal rates at the PTO are increasing. You may know that unlike the EU IPO, trademark examining attorneys at the PTO engage in ex officio relative grounds review of all applied for marks for confusing similarity with already registered marks. They do so under Section 2D of the American Trademark Act, the Lanham Act. By 2017, 1 in 6 applications at the PTO were being refused registration on the basis of confusing similarity with an already registered mark. And that proportion is 1 in 5 in NIS Class 25 apparel goods, which is the dashed line on the slide, a class that I will be returning to a few times. Seen another way, by 2017, in Class 25, the dashed line, over half of those applications that failed ex officio review did so on the basis of Section 2D confusing similarity with an already registered mark. And you can see the trend lines from 2003. But from the beginning of our study of the US trademark system, our aspiration was at some point to do something you may be surprised to see American legal academics doing, which is to study something other than the US. Our goal was to try to study the global trademark system, the one that sophisticated trademark lawyers have long internalized as the system in which they operate. To their great credit, many trademark offices around the world are now doing the hard work to make their bulk data publicly accessible, including the UK IPO, IP Australia, and the Canadian IPO. But it may be some time before scholars have access to anything like a true global dataset. Short of that, Jeanne and I turned our focus to the EU trademark system. We did so in part because the EU IPO has very generously posted its bulk trademark data online. The data set is not quite research ready. It's an XML format and is a bit of a beast, but it's certainly usable. And for that, we are enormously grateful to those who are responsible for this resource and have made like all of our work possible on this topic. We turned our focus to the EU system also because we think it has various characteristics that make it especially revealing of broader global conditions. And frankly, it's a lot more interesting than the US system. You will be aware that the EU consists of 27 nations speaking 24 EU-recognized languages, and of course many more non-official languages. It is a massively multicultural, multilingual marketplace, one that is composed of one separate national markets that are now increasingly integrating into a single market. From its first registration of marks in 1996, the EU trademark system has both fostered and been forced to cope with intensifying economic, cultural, and linguistic integration. Indeed, we are tempted to say that as the most expansive and complex transnational trademark system in the world, the EU trademark system is uniquely a microcosm of the global trademark system and the many challenges it faces. Though I must say, no less an expert than Graham Didwoody, who I know is beaming in right now, has questioned Jeanne and me on this microcosm idea, and I think with some good reason. One such challenge faced by the global trademark system, as by the EU system, is quite significant. Transnational market integration adversely affects both the supply of and demand for trademarks. On the supply side, as a market integrates, the number of trademarks that are effective in that market declines. To be effective throughout the market, a mark must be effective in each of the languages and cultures of which the market is composed. That is to say, the mark must lie within the intersection of the various sets of marks that are viable in each national sub-market. For example, when an American company applied to the EU IPO in 2011 to register the mark Curve 100 for wood stoves, the company could have been forgiven for having had no idea that one of the terms used in that trademark is highly offensive in Romanian. But the EU IPO was apparently well aware of this fact and denied the registration as contrary to the morals of, quote, the general Romanian-speaking public in the EU, unquote. And I apologize to any Romanian speakers for suddenly having recontextualized that word. Further impacting supply is that separate submarkets in trademark law's territoriality principle may once have allowed different entities to adopt identical marks in their respective submarkets without any risk of conflict between the territorially separated marks. But in an integrated market, such conflicts are common. Reducing the supply of available trademarks even further is what we designate the reverse Babel problem in trademark law. In the European Union, as in the United States and elsewhere, trademark doctrine conventionally subscribes to the following doctrine. Two orthographically and phonetically different marks from different languages, such as apple and manzana, may be confusingly similar if they convey the same meaning to any significant population of consumers capable of understanding the terms in both languages. Thus, a registration for apple may also claim the translationally equivalent word in every other language in the market, as well as the phonetically and orthographically equivalent word in every other language. In the year 2000, descendants of Baron von Richthofen sought to register the English language mark Red Baron at the EU IPO for various goods and services. But owners of the already registered Spanish language mark Baron Rojo succeeded in preventing the registration for the goods on which they were already using their mark. It was an easy case. That's the supply side. On the demand side, an integrating market increases the demand for competitively effective marks. There are simply more and more entities claiming exclusive rights within the same commercial sign system. For a quick example, consider the global automobile industry and Infinity's and Audi's simultaneous use of the letter Q. An industry expert has worried that choosing distinct marks from the shrinking pool of available words will lead to, quote, car names that sound like pharmaceuticals, unquote. And of course, pharmaceutical names are increasingly notorious for their nonsensical brand names. See, for example, what I assume is pronounced as come here naughty. What is this? Do you recognize this as a brand name of anything? It's the brand name of the Pfizer-BioNTech vaccine I've taken. Or is it BioNTech or something like that? But enough of anecdotes. The EU IPO data offer better insight into all of these supply and demand effects at work in the EU trademark system. So now let me finally talk about our preliminary results. First, I'll say a few words about our data sets. Our main data set is the EU IPO open data set. The 2019 version we used provides detailed information on each of the 1.9 million trademark applications filed at EU IPO from 1996 through 2018. We'll update all of these results once we can work with the 2021 version of the open data set, which we hope will be released by the end of this month. We additionally developed two original data sets to supplement the EU IPO open data set. First, to study translational similarity, we used the Google Translate API to identify the source language of each applied for word mark at the EU IPO, and to provide translations of each mark into each of the 5 major European languages. Second, to study the third-party trademark opposition process at the EU IPO, we assembled from the EU IPO's website a dataset consisting of detailed information on the opposition history of each application from 1996 through 2018. And there, too, we had to scrape the website. To study common word depletion in each of the 5 major languages, we focused on the 20,000 most frequently used words in each of those languages. We developed these word frequency lists from the corpora listed here, and you can see in the percentages the amount of daily usage for which the 20,000 words accounts. We also used a data set allowing us to perform a sentiment analysis of frequently used English words that are either claimed or not claimed as marks. Finally, we used an updated version of the .com TLD zone files of all .com domain names. So, finally, some results. I'll focus first on English, by far the leading global language. And here I'll quickly offer up some data, some factoids admittedly, to try to give a sense of general conditions. I should say that we've written an early draft of the paper, for better and worse, in the American legal academic mode, so it's a healthy 87 pages and 344 footnotes. You are most welcome to consult the thing for a lot more detail on everything I'm about to say, but God help you if you do. The 1,000 most frequently used words in British English account for 70% of daily British word usage. Of these, 756 identically match a mark registered at EU-IPO in 2017. 244 remain unclaimed. And as you might expect, it's mostly the usual suspects. For example, the first, Afraid, as a brand name. Well, Halloween was just now, and maybe it could have worked there, but it's not claimed. I'll quickly say that sentiment analysis, shown in the parentheses in the table, quite consistently supports our larger claim, up through the full set of the 20,000 most frequently used words in English. English words that are already claimed carry, on average, positive affect. They make better trademarks. This should not actually be surprising. Those that are unclaimed are probably unclaimed at least in part because, on balance, they carry negative affect and would not be good brand names. Trends over time, the figure on the left, are comparable to some of the data I reported earlier on the United States. About 77% of British word usage consists of words that identically match a registered mark at the EU IPO in 2017. What about when we take into account translational similarity? That is, when we consider English words that identically match a translation into English of any registered mark at EU IPO. Then the proportion jumps to 91%, and it jumps there very early on in the EU IPO's history, sometime around the years 00 to 05. Trademark lawyers will respond fine, but what about in particular niche classes? That's what we really care about. The figure on the right addresses this question. I'm sorry for the busyness of it on this slide, but what it's trying to show is that in, for example, class 25, and taking into account translational identity, about 80% of British English word usage is already claimed. And again, class 25 is the apparel sector, where we're seeing rates of depletion, and later on I'll talk about crowding at some of the highest levels. Keep in mind that we've only been talking about identical matches. When we take into account close similarity, conditions are shown to be far worse. In class 25, 94% of word usage is confusingly similar with an already registered mark. And for class 9, that's electronic goods, it is 95%. As the figure on the left shows, the EU system reached these levels quickly, as I was saying, sometime between the O's and 2010. As with our US project, we've struggled with estimating the depletion of possible coined terms, especially in a system with so many languages. Preliminarily, we've at least studied the proportion of English language syllables and the syllable usage that appears to be claimed by single syllable marks in the EU system. The figure on the right shows the results by class, and on the left, over time regardless of niche class. And here again, I call to your attention something like class 25. We've given this kind of presentation to people in the fashion sector, and they sort of say, thanks for telling us what we already know. It's over. We can't find any new brand names. Finally, as the set of unclaimed English terms gets depleted, we should expect new applicants to resort over time to longer, less punchy marks, to what's left over, and even marks consisting of multiple words. And that is what the data show, as shown here briefly in this slide. As for other languages, these are hard-won results, I assure you, but I'm going to flash them at you far too briefly because I want to show you what I hope you will think are some even more interesting results relating to crowding and oppositions at EU IPO. Just as we did with English, so with each of the other major languages of Europe, we looked at what proportion of daily word usage identically matches a registered mark at the EU IPO. On the left, you see trends over time, both for orthographic identity and translational identity. German is not nearly as depleted as English unless we take into account translations. But as you might expect, the Romance languages show high levels of depletion even before translational identity. In French, for example, by 2017, over half of French word usage consisted of words that were already claimed as marks at the EU IPO. And we wonder what the Académie Française would think about that. The figures on the right show identical matching by class. As with English, certain classes such as 9, 25, and 35 is general business administration services, show high levels of depletion in each language. When we turn to close similarity, the results are more disturbing still. By 2017, in each of the languages, as measured by word usage, very high proportions of commonly used words are already claimed. Jeanne and I also studied what we call multi-language words, those that are intelligible in all 5 of the major languages because they are cognates or loanwords that are the same or closely similar in each of the languages. For example, fantastic, idea, or virus. Some of these words have obvious appeal as multilingual trademarks. Of the 1,000 most frequently used words in English, and for this project we use British English, not American English, we estimate that 55 qualify as universal words across the 5 major European languages. Of these 55, all but 1 was registered by 2018 as a single word trademark. And that one unclaimed word in English is Republican. No one has claimed it. I have a parochial American theory for why this is so, but surely that couldn't explain behavior all the way over here in Europe, or over, if you prefer, over there in Europe. These figures show more generally that high proportions of multilanguage words are already claimed. Given all of these trends in the depletion of commonly used words, it should not be surprising that applicants at EU IPO are shifting toward coined terms. Identifying invented terms is not super easy in a language system consisting of 24 official languages and many other unofficial languages. But to help us, we use the Google Translate API, word lists, and the US Census list of the 150,000 most commonly occurring surnames in the US. We struggled mightily to find a list of the commonly occurring surnames in Europe. What we found, in short, is that an increasing proportion of single-word applications consist of coined terms. More impressively, the trends are especially steep in certain classes. And as shown here in the gray line, class 25 shows a steep slope. Very briefly, let me show you some basic statistics about common word depletion in the .com top-level domain. Shown here are the number of the 20,000 most frequently used words in each of the 5 languages that identically match a .com TLD in 2020. The English list is almost entirely depleted. I'm not going to show you the remaining words, but they're bizarre, just sort of random words. Now finally, opposition rates. Strangely, at the same time that we are seeing fairly stunning levels of trademark depletion at the EU IPO, opposition rates have nevertheless been steadily declining. And by opposition rates, we mean the proportion of applications being opposed by third parties at the EU IPO. Absolute numbers of oppositions do continue to increase, as shown by the gray bars in the left figure. But by 2017, we were down to an opposition rate of 11%, as shown by the line in the figure on the left. This is in sharp contrast to ex officio 2D refusal rates at USPTO, which you will recall have been increasing, and opposition rates at USPTO, which have held basically steady at about 2%. That's the bottom line in the figure on the right. We have a lot more data on oppositions at EU IPO, but in the interest of time, I'll let that wait until questions and answers. But to possibly pique your interest, the data show that the cooling off period after an opposition is filed is losing its effectiveness in resolving disputes. The line here shows the proportion of oppositions over time that never reached an oppositions division decision. They went away before reaching a decision. By 2017, it was down to about 64%. Furthermore, oppositions that do make it to decision are increasingly successful. By 2017, about 70% of oppositions that made it to decision were successful, with the dotted line showing oppositions brought on the basis of double identity, and the solid line showing those brought on the basis of confusing similarity. So what is going on? Clearly, the EU IPO is still granting trademark registrations, now at the rate of about 150,000 per year, whether there be high levels of depletion or not. We find that to cope with the problem of trademark depletion, the EU trademark system is allowing increasing levels of trademark crowding. We use the term crowding to refer to the registration of increasing numbers of closely similar or even identical marks in the same niche class by commercially unrelated firms. For a quick example, consider the mark Sandro in class 25, fashion. It coexists in the same class with marks such as Sandra, Sanjo, Scando, Sanrio, and others, to name just a few of the 35 closely similar marks registered in the class by unrelated entities. Another quick example is inevitably the English word love. In 2017, in class 25, 10 unaffiliated entities owned registrations in the term itself for apparel. And an additional 95 unaffiliated entities owned registrations and variations on the term, such as lover, lovers, or love child, or translational equivalents of the term such as amore, amoureuse, or a bit farther out, Liebeskleid, meaning love clothing in German. What this quite busy figure is trying to report to you on the slide is that over time, crowding levels at the EU IPO have been steadily increasing and are now far in excess of those at the USPTO in certain classes. The lines show trends in the following statistic. For any given mark registered in the class, the line shows the average number of closely similar marks held by unaffiliated entities in the class. It's our estimate of the average number of closely similar marks held by unaffiliated entities in the class based on a random sample. For example, here in detail is class 16, which is published goods, printed matter, and a few other things. In 2018, in that class, each registered mark was accompanied on average by about 7 to 8 closely similar marks, each owned by unaffiliated companies. If you include translational equivalents, that number rises to about 13. In the US, by contrast, trends have been relatively flat at about 5 or 6, and you can see the clear trend over time. Here is one last slide relating to the crowding data. And Jeanne and I found this particularly interesting, maybe you will too. The dots and trend lines show the registration rate of applications, that's on the vertical axis, the registration rate of applications by the number of opposers, which is the horizontal axis. As expected, unopposed applications enjoy a very high registration rate of 92%. Also, as expected, the registration rate then declines with the number of opposers who arrayed themselves against any particular application. But interestingly, at 7 opposers, the registration rate bottoms out at 52% and then begins to increase. Think of the example of love in class 25. At this inflection point, the crowded field is apparently occupied by so many different registrations of closely similar marks that the scope of each registrant's property right is critically narrowed, and incumbents' ability to prevent entrance into the crowded field declines. These crowded fields represent, we think, perhaps the final breakdown of signification in the most overpopulated areas of a trademark system. And yet, my question for you is whether crowding is really a problem. Practitioners especially might reasonably respond, yeah, okay, who cares? Half of these marks probably aren't actually used in commerce anyway. They are mere clutter. And among those that are, one is maybe used in Ireland and the other in Hungary, so what? Who cares? You might further point out that if companies thought this was a problem, they would engage in oppositions more often, and they are clearly expressing their preferences through the market by not pursuing oppositions. In theory, closely similar marks increase the likelihood of consumer confusion. And in the parlance of American-style law and economics, they increase consumer search costs. More significantly, in my view, far more significantly, is that closely similar marks dilute each other's distinctiveness in the marketplace, reducing the selling power of each mark, or in the original German of the great O'Dole case, each mark's Werbekraft. Closely similar marks create dissonance, interference, noise. Okay, that's the theory, but what about the practice? I accept that closely similar or even identical marks may coexist for the same products in a market as large as the EU's without causing undue consumer confusion or trademark dilution. But to cope with trademark depletion, the EU trademark system is allowing crowding to increase to levels so high that they threaten the integrity and utility of the EU IPO register and the EU trademark system more generally. What is it good for if there is so much crowding of trademarks on the register? I am also, though, willing to fall back on a simple, more general claim, which I think you'll find completely non-controversial. It is that the granting of trademark rights inflicts real costs on the public domain. The resource from which we draw new word marks is not inexhaustible. Since the beginnings of modern trademark law, we have assumed that there will always be enough and as good left for others. There, I've done it. I've quoted Locke and Bentham House. I hope that's okay. I'm sure it happens all the time. We have considered the granting of exclusive rights and trademarks to be essentially costless, unless the marks are functional or highly descriptive, in which case we deny them registration. Registering agencies around the world have unrestrainedly granted such rights on that basis. But we have now reached a stage of economic development where that simple assumption no longer holds. Supply is no longer adequate to meet all of demand, especially at the transnational or more broadly global level. It may be that we are nearing, if we are not already in, a kind of peak trademark condition akin to the peak oil condition predicted, but not yet come to pass for various reasons, some of which were being discussed north of here. What this simple general claim, that there are costs, counsels, is a slight adjustment of the dial, perhaps a bit more restraint as to what and to what extent we grant trademark rights. For followers of American culture, it should no longer be the Oprah Winfrey show where everyone gets a car. And if the argument from the public domain doesn't do it for you, and that may be true of my country's increasingly conservative and economistic courts, for whom there may be no such thing as the public, then I'll call this what it is. It's an argument from competition policy. The market is good, but even the market, in all its God-given glory, has ecological and linguistic limits. So in conclusion, what is to be done? Well, my first response to such a question is that you will have recognized from my accent that I'm just a simple American farm boy from New York City. So I hesitate to offer advice on something as sophisticated as the EU trademark system, or by implication, the UK trademark system as well, especially to this distinguished audience, those here and online. My second, more honest response is that I don't really know what is to be done, or at least not well enough to say in the time I have reasonably remaining. I might observe that the EU IPO would do well to engage in ex officio review. We currently see a reversal of the roles traditionally ascribed to the Americans versus the Europeans. The Americans rely on a government agency to do much of the heavy lifting in preserving the integrity of the trademark register, while the Europeans, in a laissez-faire manner, leave it entirely to market forces. But realistically, I assume there's no chance of ex officio review at the EU IPO anytime soon. And even if that were to minimize crowding somewhat, doing so would likely only worsen depletion. The two processes are viciously related. Furthermore, doing so might simply give greater advantages to incumbents at the expense of new market entrants. Also sensible might be to abandon the notion of translational similarity. EU citizens are fully capable of telling the difference between something branded, for example, Blue Hour, and something else branded Blaue Stunde. But, what would Apple think if someone else began to sell Manzana phones, or phones branded Pum or Mela? One might also insist on narrower specifications of goods or services in trademark registrations, and I know that this is a topic of some concern among some in the room, or an enhanced use requirement, an enhanced intent to use requirement possibly as well, or at least enhanced enforcement of the current requirements relating to use to minimize clutter. Perhaps we should take David Ricardo as our guide, which I assume is a better reference for Bentham House, and charge trademark registrants a higher rent for common words or shorter words, or words in the common global language, English. I assume politically this is also not realistic. My final tentative conclusion for now is that trademark depletion and trademark crowding are not processes that we can somehow solve away, especially as globalization continues apace. We can only cope with them as they worsen. As I conclude, I will leave on the screen a final slide for the many practitioners in attendance showing the companies most active at EU IPO, how much they apply, and how much they oppose. You might find some usual suspects there and usual words. L'Oreal, LG Electronics, Wrigley, Deutsche Telekom, Sky Limited, etc. Now finally, truly in conclusion, Sir Hugh said 2 decades ago in his Burrell lecture that, quote, "I can only hope that the community trademark will prove such a success that users will vote with their feet and will use it to the exclusion of national rights," unquote. Well, there is some evidence for this outcome, but of course not with respect now to the United Kingdom. The problem, though, is that the foot vote, if you can call it that, has been something of a stampede. And in this connection, my final tentative hope, basically as an academic, is that I have at least placed in question for you the possibility that depletion and crowding may prove to be among the most intractable problems the global trademark system may face this century. Thank you.
Right, well, you're not allowed to go off without being asked a few questions.
Oh, please.
We'll start with anybody here who's got a question. Nobody? Yeah. Okay. Chris.
In your solutions, one of the solutions you raise is the US style of relative grounds objection. And the focus clearly was on the EU IPO. The UK used to have relative grounds objection, abandoned in 2007. Picking up as we were.
Yeah.
What did you learn anything from that change? Just because that's something you've obviously got a test case there.
Thank you for the question, and I'm glad this is being recorded because I realize I have no notepad in front of me. This is a very important natural experiment that we have yet to look at. I wish I could at least give you some hints, but we just haven't gone into the data. It's there. The UK IPO wonderfully has placed their data online, but we haven't tested this yet. And so I'm in as much suspense as you are. And I hesitate to speculate. I'll tell you what I'd like to see. I'd like to see that ex officio review did do some work in, let's say, defending the market from noise, work that third-party opposers might not take the time to do. But that's my bias, and we'll just have to see if the data actually supports that bias.
Yeah. Roland.
I didn't see anything in the graphs that suggested it had any impact at all, but your bottom point was suggesting a change to the fee structure, and of course there was a change to the fee structure at the EU IPO. Yeah. I can't be quite so precise about when that was, but I think time rushes by. But 4 years ago, maybe 5 years ago, and you used to get three classes for the price of one, and but I couldn't see any real obvious change in your graphs. So why do you think that was not the case? Because of course some of the older registration clearly were throwing in an extra couple of classes just for the hell of it.
This I actually tested for and was personally obsessed with, much to the chagrin of my co-author. And we used to have a figure in this lengthy paper, which we've actually shortened from its previous version, that talked about the change in fee structure where you got 3 for the price of 1. There was a clear change in the number of applications for 3 classes, then over to now just pursuing 1 class. At the same time, however, the fee structure arguably wasn't that much more expensive to pursue a second and a third class. I think it was 50 euros more, 150 euros for the third. So I guess it changed behavior, but we didn't, as you have remarked, we couldn't find any evidence of a bump or a change in the trends we were seeing. And I don't know what to do with that. I don't even know what that means. I mean, it's something we're still trying to work out, which we have it in a footnote now, mentioned in a footnote. And I just don't know if we know what to do with that. But thank you for raising it, because I definitely worked on it.
Any more here? What about online? All of you lot out there haven't got anything? Oh, we've got some more here. Yes.
Yeah, we're seeing quite a bit of commentary in the last few years about the trademark systems in major jurisdictions, including the US and EU and UK, being used for purposes that don't align to trade in that country, particularly applications from China, possibly fueled by state incentives,
yes.
As well as the acquisition of trademark registrations for the purposes of online brand registration with particularly e-commerce platforms. Do you have any kind of views or data about the effect of this trend, if indeed there is such a trend?
Thank you as well for this question. This is something that Jeanne and I have been quite interested in the US context, and we both testified in Congress on this very issue. Because as you can imagine, it might be the one issue the two parties can agree on, is let's do something about all of these fake trademark registrations flowing into the US system from China. And the US has changed its policies, insisting on domestic representation. You have to have a US lawyer represent you, even if you're Canadian, when you're applying from abroad into the US system now. In the US context, and I'll turn to UIPO, in the US context, we found that the various rules the Americans have established haven't made much difference. The Chinese government has agreed to remove some of the incentives it provided to its citizens to file for trademark applications in the US. Incentives that were often in cash form, that were in excess of the fee to apply, and so you could pocket the difference. There's still, the PTO is being flooded with registrations from China to the extent that I wish I had the data at my fingertips, but I think a few months ago was the first month that there were more applications from China flowing into PTO on the trademark side than from the US. If you study the specimens of use, because as you know, in the US we insist on proof of use before registration issues. Many of the specimens of, we were estimating 60% of the specimens of use are fake. They're doctored, photoshopped images. What about Europe? Because we thought if this kind of conduct is occurring in the US, surely it's going to be happening in the European Union as well. The fee structure is not such that it would dissuade people from trying for European registrations. And now I built up to, regrettably, a real letdown. I don't know yet. We're waiting for the 2021 data. So we can see it's really a phenomenon we saw in the US starting maybe 4 years ago. And our data did not show significant increases from China up through 2017, but we would expect to see 18, 19, 20 a spike, unless they're maybe just doing this in the US. By the way, we have also speculated, why are the Chinese citizens doing this? Why is the Chinese government doing this? Is it sabotage of the trademark system, this important national infrastructure? No, it sounds like maybe one theory is, this is my own pet theory, it is political leaders in the municipalities trying to show that they're causing great economic progress, proving their worth to the political center, maybe seeking promotion with sort of Potemkin numbers for economic development, but who knows?
Thanks, Barton. It's such a comprehensive paper that there's not much that we can really ask you about the content of, which is why we're all asking about other things.
Yeah.
But I was wondering, given that you mentioned China, whether you would dare to expand it even further, because there was a fascinating case 3 or 4 years ago where Michael Jordan managed to get a Chinese trademark removed from the register that was his name phonetically in Chinese characters.
Yeah.
And I noticed when I visited Japan that there are, interestingly, some English language trademarks there that are unique, like Lawson and stuff like that. So I just wondered whether you had thought about that. And obviously you would need partners in those countries.
Yeah, we would.
I don't know whether you...
Thank you for this question. We've thought about it, certainly. We've been contacted by Japanese scholars who want to initiate this kind of project in Japan, which is far beyond our capabilities. The European languages we can work with, but not Japanese or Chinese. Our hope is that it could be implemented in China in some way, not by us, but possibly by colleagues based there. I confess I don't know if the Chinese have released their bulk data. Maybe you can search online for individual marks, but to release like the 10 gigabyte data set is not something I would expect of that country. But to be honest, I haven't looked for it with any, earnestness. But I will say the problem that all of these scholars might have, including us, is what I'll call the denominator problem, which I suspect many of you were intuitively thinking of, which we're arguing that an increasing proportion of all potential trademarks is being claimed over time. Well, how can we figure out the full set of all possible trademarks, especially when we take into account coined terms? And my colleague, Rochelle Dreyfus at NYU, has been asking us about this since the first days of this project. Like, what about coined terms? And in the lengthy paper, we talk at length about the denominator problem. which becomes an even, I guess, in individual systems like the Chinese system, God help them figuring out what constitutes a coined term in that system. It is almost as if in studying the global system, we have a slightly better time with this denominator problem because we're looking at the intersection of all of these languages. You want a word that works everywhere for a successful global brand. A single letter is great because Q, for example, will work in just about every place. But once you get into words, you have the problem that we talked about with the Bloomberg report. So there, at least, the denominator problem is a little easier. But I think in Japan and China, my intuition is that this might make their projects not untenable, but even more difficult to persuade others than ours is.
Yeah, at the back.
Thank you. Thanks, Barton. I have a couple of questions.
Yeah.
The first is methodological, and just whether or not you were only looking at plain word marks, or when you were looking at words, does that include figurative and device marks? Because obviously that might undo confusion.
Yeah.
So there's a question about whether plain word marks should be banned. You can get a word, but only in a figurative sense.
Yeah.
The other question was, well, the other point I was thinking about was market use undoing confusion, in as much as we can withstand lots of registrations for love in relation to clothing because other aspects of product get up or other trademarks undo that confusion. And I was wondering whether you've looked to any enforcement, sort of looking at the enforcement side, and whether judges, for instance, are perhaps getting more amenable when thinking about confusing similarity to do sort of a surrounding circumstances style analysis to try to bring in those market factors to correct for the word mark that's central to the case.
Yeah. Thanks very much. So the first question is a very good one on stylized marks versus plain, what do we call them in the US? Well, they're all caps marks, or standard character marks.
Word marks.
Word marks, but without the stylization. So just the term Coca-Cola, but not in the well-known script. We reduced all applications to, in essence, to standard character marks, which I will confess is a limitation of our method. I think we might have tested for stylization, but didn't find anything interesting enough. But there's your clue that, well, we're motivated into what we think is interesting and not to try to make our point. And I'll note this in the recording of all of this to go back, because I think it's a valid concern. And then related to that is actual market use. Yes, I hesitate to talk about the likelihood of confusion test in Europe. Ilana, I don't know if she's here behind a mask, or Dev is watching online, but they've written at length about the likelihood of confusion test, as you know. Here's a deflection of an answer I'll offer to you, which is to regret the trade-off between confusion and dilution, which is that as judges allow for finer distinctions between similar marks based on use in the marketplace, we allow for more marks to coexist on the basis that they're not confusingly similar, because they're used in slightly different ways in the market. Fair enough. The marketer might say, but that becomes a problem because I actually want to be the only company using the word love in the marketplace. Or, okay, fine, I don't get love, but at least give me amore, amore or amoureuse or something like that. I want to be the only company. Not because of confusion as to source, but for the selling power of the mark, the Werbekraft of the mark. And there is like the two tracks of trademark thinking. One is I would call it like the lawyer's track, which we're here for confusion. The marketer is thinking about something else, pursuing other ends. And so, as far as I'm concerned, I'm all for more attention to fineness of differences between market use in order to allow more marks to coexist. To get a little fancy and maybe too clever by half, the idea is that over time, allowing such marks to coexist, even though they're used in slightly different ways, and therefore are not necessarily confusing, will teach consumers to tolerate crowding, will give consumers greater sophistication in the marketplace. They'll tolerate slight differences. Now here's where I'll go off the rails and be the 13th chime that calls everything else into question before it. I also appreciate that because I don't support the marketing view of trademark law. It's about the ideology of consumer society and artificial product differentiation. And I think trademarks, and this may be a bit puritanical, but they're very important for source denotation. But Class 25 is filled with a lot of marks that are not at all about source denotation. They're about hierarchy and differentiation of people and democracies and providing sumptuary law to systems that otherwise would not tolerate sumptuary law. And I don't see why trademark law needs to be placed in that position. The old search cost version of trademark law, consumer confusion version of trademark law, is a very honorable tradition. The new fashion-based version of trademark law is regrettable. In any case, I don't think it will survive the century because of consumer society's impact on the environment. By the way.
Any more? Yes, Lynn.
We've got one in from...
Oh, right. Read it out.
So with the trend of trademark depletion, does this give more strength to existing well-known marks or famous marks? And furthermore, does it make it harder for newer marks to become well-known or famous?
Yeah. So thank you out there for this question. And in the paper, we developed this more, and I regret actually that I didn't say this a bit more explicitly or at all explicitly here, which is, and it's part of the almost resignation I have in like, what do we do? The depletion does create significant barriers to entry for new market entrants. If you accept the argument that many of the best marks are already claimed, then how do you enter into that sector of the economy with a second best mark, a less preferred mark? Well, yeah, you can still get away with it, but it will require more advertising, more finesse, more luck, all of these things, a better product. And this creates disadvantages for market entrants. Well, then how do we solve that? Well, we could place limits on like depletion, but that would create further barriers to entry for market entrants. And Jeanne and I, in our own thinking about this, feel like we're sort of caught between, on the one hand, wanting to prevent the barriers to entry that have already developed through depletion, and yet many of the policies we'd like to implement, higher fees, for example, I don't know, something like that, those would impact more likely entrants rather than incumbents. So it's a vicious trade-off in 100 different ways, this problem.
Maybe you could have higher renewal fees than application fees.
Yeah.
As if this mark is worth something,
Yeah.
like a sort of patent fees, although they're all ridiculously low, but
Yeah.
the same idea. Every year you renew, you pay more.
Yeah.
If the mark is no good to you, you don't want it, you don't pay.
And this is why I end with this simple observation that there are actually costs to the granting of trademark rights. It's not an anything goes situation anymore, as it might once have we thought it was. You know, all of infinity is open to everyone else. And so our hope is at least this paper and the US paper will develop a sense of cost to this that might lead to some slight changes in the cost structure. I must say, though, that International Trademark Association, I suspect they would have no interest in this whatsoever. Coca-Cola registering, and we were looking at entities that have registered in all 45 NIS classes, Amazon, for example. They want to renew in all 45 classes. That's actually fairly expensive when you're renewing per class, and maybe they're renewing 100 different marks, or in their case, maybe 500 different marks. But then again, Amazon is a $1 trillion company at this point. And for them to claim ownership in a word in the common language, especially English, it would seem that they'd have to bring a little more to the table now than they once had to. Why? Because we've begun to realize that there are limits on the trademark system that we hadn't yet reached in the old days, but we have now reached.
Yes, Richard.
So I've been studying your last slide with some interest and forming my own hypotheses as to the distinctions between being long on the x-axis and high on the y-axis. But problem is that, of course, your x-axis is just numbers of applications.
Yeah.
Do you have a version of the slide with numbers of classes?
Yeah.
That, I think, would tell you a bit more.
The answer is no, we do not. And it's a very shrewd question that especially a trademark lawyer would ask, I think, about our entire method, which is we've been focusing on the number of applications rather than number of applications times classes contained in those applications. And I will agree to the, I don't know if this was an implication, but I'll happily take it as one, that to take our approach to the next level, we would have to incorporate that additional dimension and present to you an x-axis that is the number of classes. And I haven't heard this objection from economists' friends explicitly, but their work will typically operate in terms of number of classes rather than applications. And in fact, PTO and I believe EU IPO as well in their annual reports, that sort of thing, will focus on the area you're focusing on, which is number of classes. That's a lengthy way to hide behind the fact that no, I don't have any answer for you, but I agree with you that it could be highly revealing. Because let's take Daimler, AG, one wonders how many classes, some of the things they're, how many classes they're registering in. Pardon me? Which one?
Daimler.
Daimler.
You've got Daimler.
Oh, it's misspelled. that's my personal fault.
Yeah, it's confusing similarity.
Yeah. And Wrigley too, maybe. Well, I don't know, but one can wonder. Samsung.
Well, you've got two supermarkets there, haven't you? And they some of them like registering across the board.
Yeah.
Even though they might not apply their brand to the actual product.
Yeah. And by the way, just to be clear, what's being shown here, LG Electronics files thousands of trademark applications, but very few oppositions. And meanwhile, you have something like Kaufland with, I don't know, 3 or 4 applications, but a high number of oppositions. Similarly, Sky, a single, I realize this is a word at some issue currently. Very common word. Just a few applications, registrations, an enormous number of oppositions. We have similar marks in the US. Monster sues everyone who comes anywhere near it for a relatively common word.
Right, I reckon we are probably done. We're over the hour.
How nice.
And the bottle is calling over there.
Very good. Thanks very much.
Thank you very much indeed, Barton.
My pleasure.
Absolute good. Well, drinks await outside.